Okay, now I'm just wondering, looking at what has happened, what has transpired so far between, the EFCC and on this particular matter, and the response. They say that this is about that administrative procedures cannot take precedence over criminal matters. Now, the processes of the NJC, aren't they just merely administrative?
Well, they are quite, it is administrative, but what their lordships, they are saying here is, it is a condition precedent. And in law, we all know that when you are supposed to comply with some conditions before you take some steps, without complying with those conditions, any step taken will be a nullity.
So basically, this is a technicality.
It is not a technicality. It is not a technicality. What we are saying, or what the Court of Appeal is saying here is, you have to wait until NJC has dealt with matters bordering on official misconduct or breach of oath of office by a judge, which also amounts to a crime, before you can file charges against a judge.
It is interesting that there are some cases that, for instance, it talks about rape, stealing, and saying that the EFCC doesn't have to wait.
They don't have
You've talked about how a judge, if a judge is in the dock without being cleared by his colleagues, I mean, by that I mean derobed, or derobed, as it were, by his colleagues, it is an anathema. In that instance, if a judge is accused, and I think the key word here is still an accusation of, either stealing or raping anyone, for instance, wouldn't that person be facing trial as a judge?
Very good. At that stage, if a judge is arrested, God forbid, for rape, and is now going to face trial, at that stage, the NJC on its own will do something about it.
What are they going to do? Suspend the judge?
I am sure they will do something about it.
And the reason I ask this is because remember that our principles are that, an accused is innocent until proven guilty.
Yes.
So the actions that the NJC would take, the question will be, what sort of actions? Wouldn't they be limited by the very principle that a suspect is assumed innocent until proven guilty?
Yeah, I quite agree with you. But where a judge is accused of rape or manslaughter and is now going to go through trial, ordinarily, under civil service rules, when you are facing such a criminal trial, there is what they call interdiction. Normally, interdiction means pending the outcome of whatever you are facing, you step aside. So if that happens to a judge, God forbid, that is now going to be in the dock for rape or manslaughter, which has nothing to do with official duties, either under the civil service rules or under the inherent powers of the NJC, they may ask him to step aside. Not that you are no longer a judge. Step aside until you clear your name.
Recall that on this particular matter, I mean, the 5 judges who were initially arrested by the DSS and later on prosecuted by the EFCC, it took a while for the NJC to be able to say, judges, step aside. In many instances, those judges were still sitting on matters before
they were not immediately charged. They were not immediately charged to court.
True.
They were not immediately charged.
But when they were, it took a while for the NJC to say, step aside.
Yes. Now, that is why, because they were all accused of official corruption. And what this judgment is saying today is that allow NJC to do its own bit before you step in. Let NJC punish, review, or do whatever before you can now step in.
Could it be that this was the stance that the judiciary held all along in the matters concerning the arrest and the invasion of the homes of the judges?
I'm a legal practitioner. I'm not a judge. I wouldn't know.
But can't we infer?
Well, I don't want to infer where I don't have basis. I don't want to be speculating. I want to act on facts, not speculation. I don't want to engage in it.
It is interesting that this, I mean, has finally, this has come to the fore. And if we recall, Justice Nganjiwa was one of the judges whose homes was invaded by the DSS. Isn't that right? I'm
not quite sure Nganjiwa's home was raided. No, I don't think so.
But he was arrested by the DSS.
I think he was invited. I don't think his house was raided. I'm not quite sure. I don't have the facts.
Okay. Yeah. So if we've seen how the other cases have proceeded, and on this particular one, we're seeing this particular ruling, we're seeing this particular judgment, can't we say that all along this was the stance? Because right now, a number of lawyers are saying that they have been vindicated by their stance that it was illegal and it was wrong for the DSS to have raided the home of the judges in the first instance.
Well, I wouldn't, like I said, Section 158 of the Constitution is new, is a novel issue. There has been no pronouncement directly like this we have in this judgment. And mind you, this objection was raised before Justice Akintoye in the Lagos High Court, but Justice Akintoye overruled it. So until the appeal court now, and who knows, maybe Supreme Court may disagree with them. So let's wait until the Supreme Court finally. So I don't want to speculate that this has been the stand, and the raid of the homes of the judges is a very volatile issue, which has attracted a lot of debate and arguments and whatever. And of course, lawyers will always, members of public will always give comments till eternity on the point. Because I mean, they said it was a midnight raid, it was an evening raid and whatever, and all these kind of things. But like I said, I think for a proper synergy, there should be collaboration among all these agencies. One should not see the other as an enemy. They should be collaborating. The FCC is doing a very great job. The DSS is perfectly on top of the security of the country. I agree. I mean, it's doing very well. But let them collaborate. Otherwise, it's kind of these technical reverses in court to be avoided. Let there be collaboration so that we can move forward.
Do you think the judiciary is elitist? I mean, when you look at how things work, I mean, the fact that it would seem that the NJC is just going to sit patiently and wait for you to bring your petitions. If you don't bring any petitions, nothing happens. You can run as far as, I don't know, but I'm just picturing in my mind that it would seem that, security agencies can run around the place doing their investigations, but it would seem that the NJC will sit quietly and wait. If you do not bring the cases to us and you do not look for how to clear, for us to clear these people, then these cases are going to go nowhere as far as the judiciary is concerned.
Not all cases. All cases that border on official corruption and bribery as captured under paragraph 21 of the third schedule. Things that have to do with the oath of office of the judges, their code of conduct. Those are the ones that they say, you must draw the attention of NJC. You must come before the NJC for a petition before you move ahead. But in other cases, you can't. If a judge goes to a party and then is tipsy or is drunk and is driving and then carelessly he kills somebody, whether manslaughter or murder, that doesn't require intervention of NJC. But when you are saying a judge has taken a bribe or gratification or what have you, what they are saying is that go to the NJC, report him there, whether DSSS, NIA, EFCC, police, NDLE, or whatever the body is, file a report with the NJC.
Do you think that this would also affect the Code of Conduct Bureau, for instance? I want to imagine that the judges will have to declare their assets.
They must.
If they have to, do you think that if the Code of Conduct Bureau finds any one of them wanting, do they have to report to the NJC first, or can they take action as they would in any other case?
I think the law should be looked at clearly. If breach of Code of Conduct rules will also be captured by paragraph 21, 22, then you just have to go to the NJC first. But I think as a special body, recognized by the Constitution, and under their harmonious construction, the Code of Conduct may likely be allowed to proceed without having to go through the NJC. because the code of conduct is also a creation of the Constitution. And when you talk of a general rule, and you have a specific rule, the specific will prevail over the general. So the code of conduct may come out as an exception here.
But it's an arm of the executive. That's your reading.
My own humble understanding is provided for under the Constitution. The code of conduct is under the Constitution. And all other provisions, I mean, this is a specific one. And it's the body specially equipped to do that. Yes. It's not a general issue. So all others under the paragraph 21 or paragraph 22, as the case may be, may still be going to the NJC. But when it comes to specific, like code of conduct, I would think that the code of conduct can go ahead.
Well, we have to thank you most kindly for coming on Sunrise Daily this morning.
Thank you very much.
Mr. Ahmed Raji is a senior advocate of Nigeria. Sunrise Daily will continue in just a moment. Please stay with us.
Thank you.